Let's get some reaction here. In studio with us today, national trial attorney Mike Jaafar is along with us. Big news conference, 5 arrests, including 2 physicians. Even, you know, those text messages, the one text message, alleged text message from Dr. Plencia. I wonder how much this moron will pay. What stands out to you?
I mean, people are going to gravitate to the inflammatory. What you said is the most inflammatory piece of this. But what I tell people is there's a flip side to every coin. When you see these press conferences by the alphabet organizations, as we call it, and they have this overwhelming just press conference, right? What you're not going to see is a press conference by the people who represent the defendants, right? There's always a flip side. We don't know what it is. We're going to see it in the trial. But these alphabet organizations always want to bring in the hammer and put the defense on their heels. And whenever you have something inflammatory like that text message, I'm wondering how much this moron will pay. I mean, that's very inflammatory. We don't know what came before that and what came after that. But there was a little nugget at the end of that press conference when the DEA came up and they said, well, you know, it started with the doctors, but it ended with unscrupulous people, and the doctors should have, you know, protected him. What people don't know is that these pain doctors, the thing that keeps them up at night is weaning people off. I know of many pain doctors, I represent a few, where they'll get death threats from their patients when they cut them off, right? I'm not saying they shouldn't. What I'm saying is it's a very difficult world. And there's so much complexity in this, and sometimes it ends up with actual drug dealers, like the ketamine queen. I don't think this woman has any defense to what they're coming at her for. She's just a straight-up drug dealer who takes advantage and preys on people, from what I see. But the people that led up to it also were indicted, and we just don't know the level of their culpability or whether or not they could have done anything different. I mean, are we supposed to believe that, let's just say somebody like Matt Perry, with the amount of resources and wealth he has, that he wouldn't have eventually got there? That's going to be the defense of the people downstream. But I don't see any defense right now for the ketamine queen. But that text message was with the doctor. It's very inflammatory. I tell my consuls, do not send text messages that you don't want to be played at the Super Bowl. If you don't want to play it at the Super Bowl, don't send it. Don't send an email, don't send a text. Pick up the phone and call. But this doesn't look good. But I know that there's many, many, many backstories, and I'm looking to see what the defense is going to do.
All right, we do have to leave it there, but no doubt we are going to be following the updates that come out of this prosecution of those 5 in the death of Matthew Perry. Or let's bring in national trial attorney Mike Jaafar. Real quick before we get to break, Michael, I want to ask you about this use of force continuum. We see it a lot with police officers who are on trial. This is a layperson. This is a civilian. Is it going to be compelling to this jury to hear about when to use of force and when not to? I
think it's absolutely necessary, because this is the entire theme of the defense and the prosecution. See, look, in Florida, they have a law, Chapter 776, that says exactly when you can and cannot use deadly force. It literally says, there's 2 paragraphs. You can use regular force, but not deadly force if you feel that somebody's going to hurt you. And then it goes on to say, but you can use deadly force if you're in imminent fear for your life. None of us know what her state of mind was. We know what she's telling investigators. She was telling, we don't know if she was lawyered up at the time. We don't know if she did a Google search. We don't know if she really believed it. But she said, I thought that A.J. Owens was going to break down my door and kill me, so that's why I shot, right? So we need to get into her mind. And so this, I think this expert is all, if the jury believes him, and if he comes in and finishes the testimony in the way I think he is, which is a layperson would in fact be in fear for her life, I think this would be important, and this is the entire case anyway.
It's the entire case, and we're still waiting to see if Susan Lorenz is going to make a decision, take the stand in her own defense. Don't go anywhere. We have a lot more ahead here on Court TV Live, your front row seat to justice. Let's bring in trial attorney, national trial attorney Mike Jaafar, who's here in studio with us. He's talking about fight or flight, really that your body can have a response not to the actual threat, but can still create all of these things inside of a person that can give them this anxiety. Is that helpful when you have a manslaughter case where no one in this room is saying this was an intentional murder?
I think it can only be helpful because what the prosecution want the jury to believe when they go into the box is that she was just a bigoted woman who hated A.J. Owens and wanted to shoot and harbor, right? The defense want them to believe that, you know, she actually was in fear for her life. So I think that this, if the jury follows this type of testimony, it's highly technical, highly scientific. If they follow it, then I think it could only help because they will blunt some of the elements of nefarious acting by Susan Lawrence, because at the end of the day, it looks really bad. A mother was knocking on your door, you shot her, you had prior incidents with her. So I think if they can paint a picture that she was in fear for her life, I think it can only help for even with the manslaughter.
And we're still waiting to see if she is going to take the stand. We're going to learn that all together. We're going to get to a break, get you back in for more testimony on the other side. Stay with us.
Let's bring in our guest this hour, in studio, trial attorney Michael Jaafar. And Michael, let me start with you. Is it surprising to you or not that she is choosing not to testify, given she's the one that's saying, I was in fear of my life, that's why I shot through the door?
I think her defense attorneys must have tasted something they didn't like in their private conversations with her. There's something they didn't like, they tasted it, and they said, you know what, this is going to blow up our entire case. There's something that they saw, because at the end of the day, it could have gone either way. If she would have testified, I mean, she's a 6-year-old woman with no criminal history, right? So she has, on paper, the perfect person on paper to testify, because of the fact that she's we all want to know what her state of mind was at the time of the incident, right? You're going to go to jail for potentially 30 years. What was your state of mind? We've brought in every expert. Some of the experts were not really great experts, but we want to know what your state of mind is. So for her not to testify, I have to assume that her defense attorneys tasted something they didn't like.
So, Michael, looking at the evidence that's been presented in this case, where do you think this jury's going to come down if you were to pull out that crystal ball?
That's a tough one, Judge Ashley. I'll tell you why, because this is rooted in self-defense, right? So in Florida, right, there's Chapter 7-6 where they tell you exactly how you can defend yourself. You cannot use deadly force in Florida unless you have imminent fear of yourself being killed, right? It specifically says you can use force, but not deadly force, if you feel that someone's going to harm you. But you can use deadly force if you feel if you have an imminent threat to be murdered by somebody, right? So the closing argument for the state is going to say, look, somebody knocking on your door and yelling at you because you just had an altercation with their kid, that does not rise to the level of you, a reasonably prudent person, feeling like they were going to be harmed, killed, which is why her defense brought in the testimony, well, she had a friend, she had PTSD, she had a friend who was gagged and raped. This is all relevant, right? Do I think the jury's going to buy? I don't know. It's a tough one. There's only 6 people on the jury, Judge Ashley.
That's
right.
So
the state only has to convince 6 people that she went too far, right? And the PTSD and all of that, it's just a cockamamie story that you could just disregard. That's what the state's going to say tomorrow.
Yeah. You're going right to my next question, because he did not give alibi notice. He's not pointing the finger. And so let me first touch on, Michael, the evidence that they have. They have a match to him under the fingernails of the victim in the case. They did a search warrant and executed it. In the home, for instance, they found a cut-up straw hat that matched the hat that was in the photograph of the person walking by in front of the house. They also found the shoes that match. One of them cut up into little pieces in a plastic bag under a chair in his living room or under a couch that was kicked back. All of that to say, he says he was framed. Can you say you were framed without pointing the finger at someone else?
Anytime a defense attorney says that their client was framed, that means there's no defense. So that's just, I start with that.
Some insight into the world of defense attorney work.
That means there's no defense. It means it's death by 1,000 cuts. This defense attorney knows he's got not only like an uphill battle, but he's got no defense. Like, he's got to just do everything he can. You're seeing a bunch of haymakers and Hail Marys that they're going to throw. So he wants to hopefully bring us all into the swamp of, well, maybe, hey, this Denali, did you see, maybe it was far away from his house, or because at the end of the day, there's no defense. That DNA evidence under the fingernail, that's killing. That's the killing blow for the defense. And then the cut up straw hat and the sneakers. Oh my God! Well, the police put it there. Oh yeah, sure. He had a motive, but he didn't actually do this thing.
Welcome back to Court TV Live. I'm Michael Ayala. Let's check in with our guest before we go back to court. With us, National Trial Attorney Michael Jaafar here in studio, and it flies in the face of any kind of frame job, right? You can say, oh, somebody planted the sneakers, somebody planted the hat, but if you got somebody saying, that walks like a guy, it talks like my guy, it's my guy, that's pretty powerful.
I feel myself feeling sorry for the defense attorney. He's got nothing. He's not only that, he's defending a client who's both a lawyer and a politician. We all know in American culture the most reviled people are lawyers. It's a tie between lawyers and politicians. He's got both. He's got nothing there, man. It's very tough.
Yeah.
So yeah, that walk, I mean, it looks like Robert Tellis to me when I look at that camera.
Yeah.
I mean, I don't know.
It looks like it to me. I don't even know him. And it looks like him to me, right? So you have a guy here who knows him, right? He, just like Bob said, it looks like him to me. All right. Let's bring back in our guest, national trial attorney Michael Jaafar. Michael, I'll start with you because I know from the beginning you had a problem with this witness's testimony from the perspective of a defense attorney. You didn't think it should have come in.
I don't think it should have come in. I thought it was very problematic from day one. This is something that's to be done in a motion for limine, but to be honest with you, I'm impressed with that defense attorney. That was a textbook cross-examination. That's the type of cross-examination that judges would show their kids in trial advocacy class and say, this is exactly how you do it. He caught everything. I'm a little bit envious of, to be quite frank with you, a little bit envious of that. All of us defense attorneys, we all look at ourselves in the mirror when we wake up in the morning and say, I have a killer cross. We all lie to each other. We all lie to ourselves and say we have a killer cross. That guy's got a killer cross. That was fantastic. I love that.
Yeah, and when I think about this case, that might be, Michael, the worst part of their case, because I've heard his interviews, and I was confused as to what he was talking about. It sounded so convoluted. It basically sounded like a guilty man trying to find a way to get his way out of it.
What was me? Look at me. The domestic violence is going to come in, you know, and again, he's an attorney, he's a politician. Michael, I always tell my friends, if I were to ever be indicted for stealing a rock from the moon, I'll take a plea. Yeah. Right? He's not going to have any friends in that courtroom when he if he testifies, but there's an embarrassment of riches of evidence against him. That was an awesome, awesome point in time for his defense attorney, but I don't know if it's going to move the needle in the grand scheme of things.
Yeah, I think from a sort of an artistic standpoint, it was wonderful, as we both said, but as far as moving the needle in the case, not seeing it. All right.